Hi, good evening, everybody. It's Tim Kelly, Multi-Claim Guru. Tonight, we're going to have a training session on consumer law, contract law, how to handle complaints, what you need to be doing if somebody does complain, the best way of documenting and evidencing that, and then also what you need to do if you're doing as part of an investigation service, well, investigatory process. When somebody does raise a complaint, it might be that you might not think it's valid. It doesn't matter what you think, basically, you still need to handle the complaint in the same way. So we'll run through that. If it is a valid complaint, you then need to know what you need to do from a recourse point of view. Is it something that you can resolve directly with the customer, where you can't seek a resolution with the customer? Is it something where they might want to sue you, or do you go through alternative dispute resolution? So we'll explain that process as well. And the worst case scenario is, in essence, that somebody sues you because they're not happy with what work you've done, and they seek the cost of rectification from you. We're also going to drop into a bit of contract law at the side of it, at the start of it as well. And it should hopefully signify the importance of it. Now, I'm going to start you off with a story. So we'll call the person involved in the story Bob. So Bob sat at the curbside watching people walk past. He's homeless, he's desolate, it's raining, it's cold, it's wet. He can't believe that at one point he had a really successful body shop and he worked as a sole trader. And here he is now, and he's homeless. His family have left him. He's sat on the street and he's cold and wet with no money. You know, it wasn't so long ago when life was good. And he can't believe he ended up in this situation. So you might wonder how he ended up in this situation. Well, he placed himself in that situation from not being educated and having any knowledge. The first thing he did was running a business. He operated as a sole trader. Now, by being a sole trader, he put himself in that situation where he didn't put any type of barrier between him and a consumer, and that if something went wrong, he could potentially lose everything. And that's what's happened. A customer wasn't happy with the work being carried out on a restoration for a vehicle that might have been £100,000. And this customer's took Bob to court. Court has then decided in the favour of the customer and made Bob pay £100,000. Well, Bob didn't have £100,000. So the bailiffs came in and took his home. Well, because the bailiffs came in and took his home, his wife wasn't very happy. Now there was his kids. So Bob's now divorced and his kids are somewhere else and he rarely sees them because he's on the street and he's cold and wet and depressed and desolate. And it all started off because he didn't protect himself. Now, in not protecting himself, the judge will be asking, how did he get in that situation and what was agreed with the customer? Because clearly, if you've got a business owner, you should be astute and you should be protecting yourself, but Bob didn't. So Bob didn't protect himself because he didn't have a written contract in place between him and the customer, identifying and specifying what he agreed to as part of that contract. So on the bounds of probability, a judge will look at it on the basis of what the customer tells him and say, what expectations were set? Do you know what you're entitled to under the Consumer Rights Act? That it should be fit for purpose as described in merchantable quality. Well, the consumer did, but Bob didn't. Now, Bob didn't detail with the customer what he actually agreed to do for the money. And as a result of that, he got shafted. And that's where he is. So that's Multi-Claims Guru's short story on why you need to protect yourself. And it also starts off where the worst case scenario is you end up in court and you get sued and you lose everything. The start of the story is you need to have a valid contract in place between you and the customer, and that can be both verbal and in writing, but ultimately you need to protect yourself. So before you start on any work, you need to make sure that you document and evidence what it is you're agreeing with the customer, what's being done, how much is being paid, and what the customer's expectations are. So this needs to be done at the inception of a contract at the start before you do the works. So if anybody walks in and says, how much for that? I'll be writing down, what is it you want me to do? Evidence in writing. Okay, so I'll do that for you and you actually agree the terms. Now, the fundamental basis of a contract is offer, acceptance, and consideration. They're the three fundamental parts. They're the key points. So if a case ends up in court, that is what the judge looks for. Now, in doing so, you're detailing it and evidencing what's been agreed, but you're also agreeing an expectation. Now, the comments you'll often see on the refinishes crew are about Fred in a shed down the road doing it for cheaper. Well, the story about Bob is a prime example of Fred in the shed, because unless you set the expectations of the customer and you evidence that the amount of money they're paying has a direct correlation to the quality of work being carried out, that is where you can get shafted. So Fred in the shed does the job down the road for 150 quid when really it should cost £1,000. The week later, doesn't matter whether it's Fred in the shed who's done the job or it's a manufacturer approved repair agent. The customer under the Consumer Rights Act still has the right to reject goods and services. In the event where something isn't fit for purpose and it fails, then that customer's got the automatic right to either in the first 14 days request a full refund, or they can request for it to be reworked. Now, under the Consumer Rights Act, where a customer has lost all faith in the original repairer, they can seek the cost of rectification from wherever they want. So Fred in the shed does it for 100 quid. He does a crap job on it. It then goes into, for example, a Porsche-approved body shop that's £125 an hour, and they then charge 600 quid. If at the inception of the contract, Fred in the shed didn't set the expectations of the customer to say, the reason why this cost is where it is because I'm using lower value quality of materials to make sure you can afford it. So you have to define the contract and find out the customer's expectations. You need to question them. What is it you want? Do you want a full-on concourse show-winning car quality of standard of repair? Or do you want it so you can just sell it and lock it on through a block as a trader? You need to set up those expectations because they're very different. So it's not just about looking at what work is being requested and what you actually agree to have as consideration by way of payment. It's also about setting an expectation and understanding and making the customer understand what they're getting for the money that you're going to charge them. Now, within that contract, I'm going to try and keep it quite narrow in field for what I'm discussing, in that it's about rejection of goods and services rather than the whole complex things of contracts and things that enter into them. But you should have a defined contract in every single thing that you do. So it shouldn't just be about offer, acceptance, and consideration. It should also be about your payment terms and what your expectations are. Or it could also be in terms of admin charges, storage charges. What happens when a customer doesn't pay you for having the vehicle in? So unless you define the terms and conditions of your work and contract with them, it then means it's up to a judge to try to work out what might have been in your head. Now, courts aren't nice places at all. I spend a lot of time in courts. Judges in general are not consistent in the way they might view things because personalities come into it, education comes into it, certain parts of the country come into it. And quite literally, any court that you go into, the same type of case might be viewed in a different way. So you need to take out the subjective elements of what might happen in court by making sure you document, evidence what the terms and conditions of the contracts are, and make it so that there's no grey areas in any way. So that's the importance and significance of having a written contract in place on every single job. It doesn't matter if it's a walk-in, whether it's an insurance job. Because some of the things I get or I see on the different forums, I don't do insurance work, I don't need a contract. And I'm just thinking, like, you're not Bob yet. Oh, it don't matter, it won't happen to me. It's not happened before, it won't happen again. It will, guarantee it, absolutely guarantee it. And in fact, in the last 3 to 4 years I've been assisting, doing things like this with Refinishes Crew, where I've had people saying, it doesn't matter if they don't do insurance work or it won't happen to me. I've had 3 people from the group then use my services to untangle absolute piles of crap where they're being sued by customers. And they've gone like, what do we do? And then they're absolutely terrified they're being taken to court. All of which is completely and utterly avoidable just by being organised, having contracts in place and understanding the law. So that is as much as I'm going to go into on contract law. So I could easily do a full day and night and the next day on contract law. And it certainly depends on who you're dealing with and whether it's with a customer or with a business. But to keep it simple, that is as much as you need to know. So offer, acceptance, consideration. You need to make an outline of what works have been agreed with the customer. You need to make sure that you've evidenced what the expectations are for the customer relative to the value of the money that they're spending with you. And then that way, it's not subjective in any way. So you can say that, we're not doing a mint job on this vehicle. From a concourse point of view, it's what's a reasonable expectation of a vehicle being repaired in the industry. Now, I will move on to the Consumer Rights Act and we'll go through what the definitions are in that, because basically things from a conditional point of view is that it should be fit for purpose as described in unmerchantable quality. And all services should be carried out with due care, skill and attention and with due diligence. On the elements of what you would think has been defined as satisfactory quality, again, is a very subjective term, and that's why it's important you have it in your contract. So if you can all just give me a thumbs up if you're all okay with that, and then I will then move on to the next bit. Fantastic, we've got thumbs all around. So moving on to the consumer law side of it. And again, so we are going to go through the Consumer Rights Act, and we're going to go not into too much depth, because again, so the Consumer Rights Act is about 60 points in it. So again, I could quite easily do a full day just on the Consumer Rights Act. And what I want to do is just keep it to the salient points of it to make sure that you understand how it relates to what a consumer can do when the consumer's not happy. So we've got the contract, you've not fulfilled it in some way. So I'm going to bring up the Consumer Rights Act in a second onto my screen as well. And what we're also going to do as well is that I'm going to give you a little bit of a brief understanding of the Consumer Rights Act and then come out of it. And then what I'm then going to do is go into the complaint handling side of it as well. Once we've done that, we'll then go out the complaint handling side of it, back to the Consumer Rights Act and go into a bit more depth. And then we'll look at the alternative dispute resolution and what happens in court as well. So now we know we've got a defined contract and you've set out the terms and conditions of that contract and you've set the expectations to the customer of what they can expect. A customer always has the right to reject goods and services. And in doing so, the actual aspect of law, get into it. Is defined by the Consumer Rights Act, which is here. So the significance of this is that it doesn't just relate to what you do as a business in your dealings with a customer. It also helps you as a member of the public in anything that you do where you're actually dealing with a business. So any type of product you're buying, whether it be a physical product that you've purchased, so it could be white goods, a kettle, or it could be a fridge or a TV or anything like that, or a car. But it also covers what you can get in terms of what you're entitled to as part of the service. So has that service been carried out diligently with due care, skill and attention in what they've done? And did it fit the needs of what your instructions were with them? So for example, if you instructed an electrician to carry out work on your house and you said, you defined what you want, I want the wiring to do this, I want switches in certain places. If all the switches in the house are upside down, but everything works all right, That's still a breach of the Consumer Rights Act because it's not as described. So you've described what you want. If they don't fulfill it as it's been described, they breach the contract. Now, in a situation like that, that's something that could be easily remedied. So you can then set out what measures of recompense or what measures of resolution you expect from that electrician. So you can give the opportunity to rectify it. Now, there's no difference with that with a repairer. So a large part of the things that you do as a repairer, so whether you're acting as in a mechanical workshop or a body shop, you're actually covering two different situations because you are providing a service, but you're also providing a product. So the products you're providing will be parts, and there will also be paint materials. Now, there's elements in there where you've purchased those products from somewhere else, and there might be an argument that you'd say, well, I've carried out my work satisfactorily. However, the goods that I fitted to your vehicle are faulty. And what you should do is take that up with a manufacturer who produce those parts or goods or paints, whatever. If it's covered by their warranty, not by me. Now, in court, that would fail because the contract in place is directly between the consumer and you. So if, as an example, you bought a product where you bought it from a shop, from Currys or any other type of retailer like that, the first thing they'll always try and do is sell you a warranty. Well, you might see on the wall that it'll say that this doesn't affect your consumer rights. There's a reason for that. It's because you don't need a warranty. Any product you buy or service, you're always covered by the Consumer Rights Act. Now, linked to the Consumer Rights Act is something called the statute of limitations. And the statute of limitations is the amount of time period that you're allowed to seek rise to a claim against another party. So the time limit's 6 years. Now, it covers multiple aspects of law. So not just to do the Consumer Rights Act, it could be like with anything. It could be you're involved in an accident, you've got 6 years to make a claim against somebody to do that. It could be a personal injury claim. But relating to products and services that you're buying, it comes down to, again, what's a reasonable expectation of either the product or the services that you've purchased. So as an example, if I've bought this pen, which is a fantastic pen with multi-claim guru on it, not that I do any advertising or marketing anyway. However, this pen cost me probably about 75p because I buy them in the 100. What's a reasonable expectation of that? Well, a reasonable expectation of that is, it might last a year. It depends how much you use it, but it's a reasonable quality, but it's, it's still plastic. It's not made out of solid steel or gold or anything like that. So it's disposable. Once it runs out, I'm not going to put another refill in it. I'll get rid of it. Based on the cost of this, I have a reasonable expectation in my head of what I would think would be, what type of quality is it? Now, if that pen was made by the finest jewelers in the UK and it's made out of solid gold, it's got beautiful movement in it and nice, it's got a nice refill in it, and it might be 10 grand. My expectation is it's going to last in a lifetime. It's not going to last 5 minutes or a year. It's going to last much longer than that. So if that product develops a fault in the first 6 years, and it's clearly that the fault was there because it's a design fault or something like that, then if you bought something that had a fault when you bought it, you're covered under the Consumer Rights Act. Or if it doesn't work as it's intended and it fails over a certain amount of time because it's not fit for purpose as described, or of this merchantable quality, and you have an expectation for it, then you could seek a claim from the manufacturer. Now, in doing so, there will be an argument that you've had some type of benefit out of it or use out of it. So they wouldn't give you a full refund for it if you've enjoyed the use out of it. However, they might either offer you a discount or they might offer to fix it. And the level of compensation they would give you would vary after the 12-month period. and it gradually get less because you've had more benefit out of it. So the correlation with this is that when you paint a car, a lot of you will say that you might give you a lifetime guarantee on the paint materials, or it could be up to the manufacturer's warranty. So this is something you need to bear in mind where you have done that and you have used the product, that the contract in place is between you and the consumer, not the products that you bought that you put on their car that's failed, because obviously you're going to have to contact them to say your product's failed, because it's fault, it's not down to me. And you also need to seek compensation from whoever provided those products, whether it's a part that's failed or the paint materials. So this is also the reason why you need to evidence what's gone wrong, how it's gone wrong, and whether somebody's got a valid complaint or not. So going through the Consumer Rights Act, I'll just get out of the explanatory notes. Onto my table of contents. So we're going to look at what type of contracts are covered. Ownership of goods is an interesting one. But the primary thing we're going to look at is what statutory rights are there under a goods contract. So the first thing is that goods need to be of satisfactory quality. So every contract supplying goods is to be treated as including a term that the quality of goods is satisfactory. Now, a means of determining whether goods are satisfactory could be by comparison to an example. So if you've got a comparable example that's in the shop window, whatever you buy should match what it is that's being shown as being advertised for sale. So if you buy something off Amazon, you buy something in a shop, whatever's being used as an example, whatever you buy should be identical to what it is you're buying. So if it's not, the product you bought isn't as described. Now, bringing the correlation to yourselves repairing vehicles, an interesting bit for this could be where a vehicle goes in for a repair at a body shop as part of an insurance repair, and the insurance company has agreed to use non-original parts in the car. And when you get these vang bits, it might be that the edges aren't as defined as what they are from the manufacturer. An argument could be made by the customer that the repairs aren't a satisfactory quality because the parts fitted to the vehicle don't match what it would have had from the manufacturer. Now, you could have been instructed by the insurance company to repair the car in that manner, and you might have fitted the panel perfectly correctly, you might have painted it absolutely fantastically, it looks great. That doesn't absolve you of a consumer's right to reject goods and services just because an insurance company has told you to fit a non-original part on the vehicle. Something you need to be aware of, because the contract in place is between you and the customer, not between you and the insurance company, even though the insurance company are authorising repairs. So as a repairer, this is something you need to have in mind if an insurance company tries to negotiate with you in a way where they do try to force you to use either non-original parts or second-hand parts, because again, you don't know the history of the parts that you're fitting if they're from another vehicle, if they're second-hand. And you need to, because you're providing those goods and services, you need to guarantee they are of satisfactory quality. So if you fit a second-hand door in a vehicle and the rust comes through, it's off. Now to you, shouldn't have fitted it. So where something gets into a grey area is where a customer supplies parts. So again, this comes to you defining within your contract what you've done and what you've agreed to. So in the event you can't fulfill what you're required to do under the Consumer Rights Act, because the goods have been supplied by the customer and they fail, you need to make sure you're right in that contract that the only part of the contract that you're covering from the consumer rights point of view is the service you provide in fitting those parts. Because the customer's brought the parts to you, you don't warranty them, and in the event, so only in the event where you've misfitted them would there be a valid claim. But you need to make sure you specify in the event that if these parts fail, that it's not covered under the Consumer Rights Act because the customer has provided them, and any defect that might have been on those parts that's failed, that should the customer want that work to be redone again, that the customer is liable for your labour in doing so. So an example could be where a customer brings in painted parts for you and saying, can you fit them for me? And then the paint doesn't match. Well, it's not your fault. So you need to specify all the time what it is you're doing, what's been agreed, what compensation's being offered to you by way of payment, and the customer's expectations. Now, the quality of goods includes the state and the condition, and the following aspects, amongst others, are appropriate aspects of the quality of goods. So the fitness for all the purposes for which the goods of that kind are usually supplied. So you wouldn't want to paint your car with household paint. Is a good example. Appearance and finish. So again, this is a key thing in the contract you're agreeing with the customer, where you need to define what the expectations are with the products that you're using to make sure the customer understands what the vehicle's going to be like after you've done it. So you've set their expectation. Now, the danger in not doing so is where you speak with the customer and you say, oh yeah, it's going to be mint, this, mate. It's going to be absolutely mint. And the problem with that is that my definition of mint and your definition of mint might be extremely different. Now, mint could actually be not as great as what it comes like from a manufacturer. Or mint could be that you paint it and it's better than what you get from a manufacturer's finish. So I have seen in the past a complaint about the quality of repairs carried out on a vehicle because the paintwork was better than what it was from the manufacturer, and as a result, it stood out from a consumer point of view of the vehicle being repaired. Because the paintwork carried out didn't have any orange peel on it. Now, the body shop got really cheesed off and went, it's better than what it would have been from the manufacturer. How on earth can you complain? Doesn't matter. What does the consumer rights say? The consumer's got the right to reject goods and services where they're not fit for purpose as described in merchantable quality, or they don't meet, they don't meet by way of comparison to another example. So if you've got two vehicles together, you've painted one, the other one's not painted, and you can see there's a definite difference between the two of them, customer can reject it. So you need to define the contract. You might find all the way through this session tonight, I'll keep saying, you need to define the contract. You need to have a contract. You need to specify the contract. You need to make sure the customer knows your expectations, to know their expectations. There's no arguments. Every single time I put something on the refinishes crew, people argue with me, and I'm like, I'm trying to help you. So thanks, Richard, as well for what you did today, because that was appreciated, because it is that thing where I'm trying to put information out there to make sure that you guys don't get sued. Because until it happens, you never know what it's like. Now, because I act as an expert witness in court, I attend court pretty much on a monthly basis. If it's not monthly, it might be every 2 or 3 months. And it's not a nice place to be. And I'm not the person who's getting sued or suing. All I'm doing is providing evidence to help somebody in that process. So you need to make sure that you never get in that situation and cover yourself. So point 3 there, 3C, freedom from minor defects. So if you've got nibs on a panel on a vehicle, customer can still reject it and ask you to redo it. Define the contract, set expectations. You do realise when these vehicles come from the manufacturer, even when they come new, you might find a couple of nibs in it. Do they? Yeah, I'll show you a comparable vehicle. You do realise when these vehicles come from the manufacturer that it's got plastic bumpers on it, and when the manufacturer paints it, they're not the same colour as the rest of the vehicle. I've never noticed that, but now you pointed it out to me, I can see it. Yeah, so do you know what? When we repair it and put a new bumper on it, when it comes from the manufacturer, it's from Ford. Well, when Ford provide it, it comes painted, we don't paint it. So when it comes and you reject it, 'cause it's not the right colour, that's not our fault. Do you want to make sure you're aware of that? All right, okay. You're now no longer in court for your set expectation. So this month I wrote an article about communication. Communication is the key thing in all your dealings with consumers. You need to make sure they're fully informed at all points. and even down a complaint process. A lot of people get upset if somebody makes a complaint. We'll go through that later on, but how to communicate and articulate what you're going to do to help the customer as part of their complaint, whether it's valid or not. Communication's key. So under item 4, the term mentioned in subsection 1, so it's about repairs, does not cover anything which makes the quality of goods unsatisfactory. So the area pointed out is it's where you draw it specifically to the consumer's attention before the contract's made. So that is exactly what I've just told you. So you're telling the customer what their expectations are. So this could also be where you show the customer previous work. So if you're doing a restoration of a vehicle and they want an absolutely immaculate job, you might show them different customers. You say, well, this is what your expectations are. You're setting the expectations. It could be a product you're buying. So if you were buying a product yourself from somewhere, it's where the consumer examines the goods before the contract's made. So they should expect that whatever it is you've examined, if you buy something, it should be identical to that. It shouldn't be any different. So in a case of a contract supplying goods by sample, which would have been apparent on a reasonable examination of the sample, so direct correlation, it shouldn't be any different anyway. So I'm going to go through some further ones. So just excuse me 1 second while I have a quick skim through as well. So 5 down here, the relevant circumstances mentioned in subsection 2 include any public statement about the specific characteristics of the goods made by the trader, the producer, or the representative of the trader or producer. So again, whatever conversations have took place with the customer at the start, most people have got phones nowadays, you don't know they're recording you. Or it could be that you've put something in writing on Facebook by way of messenger. Somebody's asked you for a quote. Well, personally, I'd be avoiding any type of quote by way of images. And I'd certainly be using the word estimate, but I'd always be insisting that I see the vehicle, I'd want the vehicle in front of me before I actually offer any type of contract with them. Because if you make an offer in any form, verbally or in writing, and the person you're communicating to accepts it, you've got the formation of a contract. So the instant they pay you, you've got a valid contract in place. So you need to make sure that whatever the contract is that you're agreeing to benefits you as well as it benefits them. The goods to be fit for a particular purpose. So again, this won't affect you as much in what you're supplying. You're not really supplying goods, you're providing services. However, you need to be conscious of what you purchase from any of the agents that you work with, whether it be a part supplier or a product supplier. So whether it's parts or paints. Because again, if you fit something to a vehicle and it fails, so it could be that you bought a part from a specific manufacturer, it's still you who's liable for that failure, even though it might be a product failure. So you need to make sure. So again, this also comes down as a direct correlation to second-hand parts, non-genuine parts, bang bits, that whatever it is you're fitting to the vehicle must conform to its intended purpose. So just because it looks like it might be the same thing, doesn't necessarily mean it is. It could be of a different material. And the secondary side of this as well is that you've also got to be aware of a vicarious liability in that whatever you supply, if, for example, you put a track rail end on a car and you find something that's a non-original part, but you might think it's from the same supplier, but it's not, and then you find out it's of a different material, if that fails and that car crashes, you're liable for it. So because you're carrying out that contract all the time, so when there's been discussions in the last few days about blending, which I've put some articles on the crew, The reason why I'm putting him on there is that it's not in your benefit to save money. Just do the job right. So if you can quantify it and you can evidence it and you can substantiate what you're doing, never ever cut corners. You know, educate the customer to make sure the customer's aware so that actually then do the job right. It protects you from being sued. The customer's got a better product and service at the end of it, and everybody's happy. So in the event where you don't do that, you need to communicate what it is you've done to the customer to say, I appreciate you don't have much money and you want this job to be done cheaper. In doing so, I'm going to use these parts. Is that acceptable to you? Oh, I really appreciate the fact that you're doing this job for cheaper for me. And what you've done is you've gone out of your way to find parts that aren't from the manufacturer, but they're cheaper. Yeah, I agree to that. You've got a legally binding contract that's just got you out of, it's not completely absolved you of any liability, but it's got a long way to doing it, because you can now say, well, the customer's asked me to do that. If you don't communicate that fact to a customer and you just do it, you're absolutely nailed. So don't put yourself in that situation. Anything you do in any way that isn't going to be perfect, communicate it to the customer, articulate it clearly and say, these are the options available to you. Which of these options would you like to do? Which ones are you agreeable to? So again, if you're using cheaper parts in the repair process of a vehicle, the expectations of quality, or whether they're fit for purpose under the Consumer Rights Act, changes. So again, in the worst case scenario where you end up in court, it helps the judge in understanding and having an expectation that because you've used cheaper parts, it's not going to be as good a repair. And potentially they could fail in. So they might be fit for purpose and fit the conditions required under the Consumer Rights Act under the first year they've been fitted, but they might wear out in 3 years, whereas an OEM one might last the lifetime of a car. Well, you've educated the customer from that point of view in terms of how you repair the car. Now, there's also differences in terms of you repairing a vehicle that's come in as a walk-in and also one that's under a contract of insurance. So in the negotiation of repairs with insurance companies, like I said, personally, I would never ever be using second-hand parts because you don't know the history of it. I would never be using green parts. I'd never be using non-original parts. All because if anything happens from a failure point of view, it's you that is liable, not the insurance company. But there's also a secondary side to it in that the contract of insurance is to indemnify the insured in the event of loss, and that they should be reinstated back to the position they enjoyed before that loss occurred. So if the vehicle had OEM parts fitted to it and you fit parts that aren't, the customer's not been indemnified. So for you as a repairer and as a means of making more profit and making sure that you also cover your house as well, I'd be telling the insurance company, I understand what you're trying to direct me to do, but I can't act on behalf of the customer because you're not indemnifying him. He had OEM parts fitted to his vehicle, and that's all I'm going to fit. I'm not going to save money on your behalf because if anything happens to it, I'm liable under the Consumer Rights Act. So have this in your mind from a negotiation point of view. Anytime you get asked to either cut corners, not repair the car correctly, not follow the correct methodology of repair that's been described by the manufacturer, fit second-hand parts or non-original parts on it, I'll be bouncing it back to the insurance company to put in writing that they're going to indemnify you of any potential claim made against you of the Consumer Rights Act for defective goods and services, because they're trying to force you to do that and also say that they're liable in the event of any loss, where from your point of view, you don't want that. You just want to repair the car correctly. So it helps in the way you communicate again with insurance companies to make sure that not only are you protecting yourself from any potential liability in court, you're also making more profit because you're doing the job right. So anytime I see anything in the group where it's not being done right, all I'm seeing is people who aren't educated to realise that they're losing money. They're literally throwing profit out the window. And certainly from a point where it's an insurance company involved, I'd be pushing it across by way of education to the insurance company that they're breaching their contract with their insured. But fundamentally, the thing to take from it is it will come down to you. If it goes wrong, you'll end up in court and you'll end up like Bob at the side of the road. We don't want that. So I'm going to continue going through the Consumer Rights Act. And by the end of the night, you're going to be very familiar with Bob, because Bob's not a happy man. But then again, he might be because he's not got his family and kids mothering him. So you just never know. So goods to be described. So every contract supplying goods by description is to be treated as including in a term that the goods will match the description. So if the supply is by sample as well as by description, it's not sufficient that the bulk of the goods match the sample if the goods don't also match the description. An example would be, I sell you 1,000 pens, and I tell you of these 1,000 pens, they all look like that. And then I bring out another pen, so half of them are like that. And the back of them got no ends on it. Well, if I showed you a picture of I'm selling a product that looks like this, any product I sell to you should look like that. So if you then describe it in a certain way, so I'm going to sell you a pen that's got a black refill in it, and it'll come with multi-claim guru wrapped around it, and it's got a nice little thing where you can put it into your shirt and hold it onto it. You don't need to see it to understand what it is. But if I then sell you a pen that's only half the size of it, but still has those things on it, it is as described, but it isn't as per sample. So things that might parallel to what you do are, imagine buying a load of sanding discs, and then you've requested a certain grit, but only half the box is the grit that you requested. Well, you would have a right to reject the goods and services because they're not as described. Or imagine that you pay out for the most expensive box of abrasives, and then you find out it's a box of abrasives from China that could have been bought for a fiver rather than 20 quid. So all of these different things affect you in your normal life. So it's a bit different from business to business. So the things you need to also be mindful of is that the things I'm talking about tonight come under the 2015 Consumer Rights Act, specifically relate to a business that's contracting with the consumer. Now, what happened to the Consumer Rights Act was it brought together lots of different laws and brought them under one umbrella. So the different aspects of law that were brought under this umbrella was the Trade Descriptions Act, the Sales and Goods of Services Act. Then we've also got unfair terms and conditions and consumer contract regulations as well, which is separate another part of it we won't go into tonight. But the two primary ones there are the Sales of Goods and Services Act and Trade Descriptions Act. That does relate to you as a commercial entity. So even though you're not a consumer when you're buying services, the law around how things are described and being fit for purpose and of merchantable quality still apply. So that is something that you need to understand as a trader when you're dealing with things, that you still have rights under these laws. So if any of those terms change, or if anything different from what you've agreed, that then would be a breach of the terms set out under the sections, under this section here. So I'm just going to jump out of that. I'm just going to jump into a bit of lighter stuff. So if you're all okay so far, and you're still with me, put your thumb up for me, please. So if that all made sense to you, put your thumb up for me, please. You're happy with it? Cool. Okay. Now, what I'll do for a second is, so I'm just going to stop sharing for a second while I come out of that. I'll bring it. So So Richard put on it, you can't disclaim liability for a customer supply parts, precedent case exists. I will let Richard come into this one then, because it's because there's certainly something there where you got to make sure it's still fit for purpose as described in merchantable quality. So it'd be the onus of the person fitting the parts to make sure they conform. I'm thinking is from your logic, Richard. Is that correct?
The case related to a mechanical repair situation, but basically the customer supplied a part. The garage was said to be under a duty of professional care that they should have known the quality of the part wasn't fit for purpose, even though in this case it was actually a counterfeit part. It was in a branded box and everything else. Garage fitted it, it failed, they were held to be liable, not the customer. Simple. And in the mechanical world, that is a known fact.
Yeah. And this is the thing with consumer law, it's a dangerous area. Because whenever you're working on a customer's car, you're liable, is a short version. It's a simplistic way. But it would make it complicated, Richard, where you've got insurance companies supplying parts to repairers. And again, and certainly from a green part of it as well. You know, if it's something where they're sourcing part from somewhere else and you can't define the history of it.
No, you're fitting it, you're responsible, you're liable, no matter who supplies it, insurance company or anybody else.
Yeah.
You're under the duty of care to have confirmed the quality of the part for its fitness for use.
Yeah. Interesting one. So I've learned something new there for all of you, because it is.
Could I just
my logic would have been that way. Go on, Debs.
I was just going to ask, when you were saying that for an insurance job, it's your liability to the customer, but I would have thought that if your contracts with the insurance company, so if you don't do an estimate directly to a customer, your estimate goes directly to Adatex, the insurance company is what pays you. I would have thought that the insurance company is your customer rather than the car owner.
No. So what you've got is that the valid contract that is in place is between the customer and the insurance company. So the insurance company have had the rights of the customer subrogated to them to act on their behalf. You've got basically they're acting like an intermediary between the customer and you. Now what you've got with that then is that all the insurance, so you've actually got the formation of two separate contracts. So this is on the basis that you're not an approved repairer of the insurance company. You are independent. And what you have then is that you've got the contract between the insurance company and the customer, which is one thing. And the insurance company need to indemnify their insured in the event of loss. So that should be to correctly repair the vehicle back to OEM standards using the correct parts, paint, materials in doing so. And then you've got a secondary contract, which is in the insurance company in the authority of repairs to yourself. But in that situation, you still have a valid contract between you and the customer. So in the event the vehicle's faulty, because you physically have worked on the vehicle and it's the customer's vehicle, not the insurance company's vehicle, then they still have a right to reject goods and services with you. Now, you'll find that there is solicitors who will try and twist that and say there isn't a valid contract between the repairer because the valid contract between the repairer and the insurance company, not between the customer. It's not the case. So the very fact that you worked on the customer's car means there must be a contract in place. It doesn't matter that the customer's not paid you, because it falls back off the contract that they got with the insurance company, that the insurance company's paid, and they'd have to. Because if they didn't do that, and the customer became liable for the repairs to the vehicle, which is what you'd do, if an insurance company didn't pay, you'd have to sue the customer because they benefited from the works carried out that you've done on their vehicle. And then what would happen then is there'd be a default in the contract with the customer and the insurance company, where the customer would have to sue the insurance company for breach of contract. But in the eyes of the way the judge would see it, they could see that there's a definitive line of contract in who's worked with who. It would always go between who's done the work and who's benefited from it. Okie dokie. I'll open it up to anybody got any questions so far? And excuse me as well, by the way, I've got a little fly buzzing around me and it's driving me crackers. It keeps buzzing past my head. So stick your hand up if you've got a question. Go on, Anthony. Can't hear. It's muted. It's should it? There we go.
Sorry. Yeah, I was just going to jump back to what Richard said about the case of the counterfeit part and such like that. Obviously, the garage fitting it knew it was a counterfeit part. The customer knew it was a counterfeit part. Is it not a different case when you're talking about an insurance company wanting to use non-genuine parts as opposed to a counterfeit item?
It wasn't known to be counterfeit until after the event. So it was only when it was traced back, but it was still held to be the garage's fault because they should have known better. They're professional, they're the experts, they shouldn't fit a part that's not fit for purpose.
See, I've got an issue with that because if it was something that was patently obvious. So the stuff that I get involved with it from a forensic point of view, it comes down to whether it's a patent or a latent defect and what's a reasonable expectation of the people working on the vehicle. In that, if something was patently obvious, it's a reasonable expectation that somebody might be able to work out that something's going to happen because you can see it. Whereas where it's something where it's a latent defect, it comes down to on the bounds of what is a reasonable expectation in doing so, and on foreseeability. So that case you said about there, I'd have an issue with that, Richard, because it'd be, was it foreseeable in them fitting the part that it was faulty? If you can't see it.
I'm sure that a better solicitor acting for the garage in that particular instance would have prevented that particular case. But that particular case got through, has happened. There've been a couple more, not involving specifically counterfeit parts, but they are out there. And now basically the bar is set high. So unless you can prove that the part was fit for purpose, which is almost impossible, then it's really hard. So if you buy a second-hand wheel, it's nice and painted, looks great, but in fact you bought it from somebody who welded it in Timbuktu. It's got, if you x-rayed it, loads of defects, goes over a pothole, cracks, car goes into the pavement, kills somebody. That's you on the block.
Yeah. Just a quick one, because Gary just sent me a message then saying he needs to come off the call because his daughter broke down. So I'm just sending him a message just saying I'll send him the recording for it. There you go. Yeah, it's like I said, this is why I say I'd have an issue with it, Richard, because it's like I think if there was a better solicitor involved with it, who would have defended the case better, because there's things there where I've dealt with cases like that, and it's been on product defects and whether it is a latent or patent defect, and on the ones where I've investigated it and said like it wasn't visible what's caused this fault, and the reasonable expectation is that under a reasonable inspection you wouldn't have been able to see it. I can't see where there'd be any liability held to it. So yeah, it'd be.
I don't disagree with you, but I would also put the caveat in, even if you were involved and there was a really good barrister, if you had a judge on a bad day,
you'd have
absolutely still lost. My best friend's a judge, and I know what on a bad day he can do.
Yeah.
Does it make sense? No. Do people pay for it? Yes. Yeah.
And this is what I was saying at the start of the actual session as well, in that courts are not nice places. They're absolutely awful places. And that I've been involved in cases where my expectation of the chance of us winning, because when I write a report as an expert witness, my duty lies toward the court, not to the paymaster. So it doesn't matter who instructs me, the content of my report should be the same. However, when you're writing the report, you can structure it in a way and it could alter the way it presents that information. Some engineers are better than others. And as a result of that, the better the engineer you are in the way you present it, might lead it to have more credibility with a judge in the way they see it. Just from that, it could be just a format. Something as simple as not having page numbers on the report and it's hard to read, or not being itemized going through different sections. The judge gets cheesed off with it. So just something as simple as like that, even though the content's the same, the judge might get wound up. And I've been involved in cases where I've done the best I can with the report, and I've still thought that the chances of success on behalf of the claimant who I was working with was really, really slim. And the case was found in favour of him. And I'm like, can't believe that, you know, the solicitors I was working with has been successful because it was a slim chance of winning. And I've had the complete and utter opposite, where absolutely all day long, the solicitors that had instructed me, and my report was good, without a doubt. And even the barrister said it was a good report. And the judge found against the claimant that the solicitor I was working with was acting on behalf of, all down to the fact that the judge was clearly having a bad day. And it's frightening. It's absolutely frightening. So you need to make sure you never end up in court, because they are not pleasant places at all whatsoever. I'm just going to skim back to where I was on this whilst I'm doing it. Content. So the next bit I'm going to jump into now, because you've got another, hopefully you've all got a reasonable understanding of the Consumer Rights Act. So I've not gone through what a consumer can do when they're rejecting the goods, but what we are going to do is we're going to look at how to handle a complaint. Because you now know that where a customer isn't happy, they do have the right to reject it. Now, without having specified terms within the contract, it gets into quite a nefarious area of what could be contentious, in that what you might deem or in your viewpoint be acceptable in the customer's eyes isn't. So this is the reason why you need a defined contract, and you set those expectations so that in the event that somebody does complain, you have something to measure it against. In the event that you don't have anything to measure it against, you're leaving yourself completely and absolutely open to criticism from a customer. So how many nibs are acceptable on a panel? So would a customer know what's acceptable? Is it 1? Is it 5? Is it 10? Is it 20? Well, you'll never get a perfect paint job every single time. You'll always find something in it somewhere, or a flyer will walk across it, and you might just miss it. But you need to make sure that whatever service you provide is pretty much spot on. So the first thing you need to be looking at when a customer complains, and the other thing to bear in mind as well, is that it's not about just the products that you're providing or the service of repair that you're providing. It could also be to do, or it could be about a communication issue. You told me you'd ring me when it's ready. You told me that you'll give me an update. You told me you're going to provide me with a courtesy car. You told me you're going to collect my car from my garage, my body shop, from my home, from my works at such a time, and you didn't. I spoke to somebody on the phone and they were absolutely rude. And I won't be spoken to like that. It can be a whole mixture of different things where a customer can reject or can actually complain about something. And you need to make sure that you understand what is the best way of dealing with a complaint, never to take it personally, and have a structured approach in the way you do your complaint handling. So what you need is you need to actually have a process down where all of the members of staff that you work with understand what that process is, and it needs to be documented as well. So it doesn't just need to be documented for the staff, it also needs to be documented to a consumer, that in the event that they're not happy, they understand how they complain and what their consumer rights are. Now, if you're thinking about it from a consumer's point of view, would you think that a repairer that has on their website a documented process, and should you not be happy with the repairs or the customer service in any way, here's our complaint process, do you think they would think you're professional compared to one that isn't? Because you're making it easy for them. So you're going like, listen, we care about you. We care and we understand that you want to have the best service possible. But we also appreciate that things go wrong because we're human. It's what we do. In the event that something does go wrong, here's how you complain. Now, the importance of doing that is that you're telling them to come to you. What you're allowing yourself to do is you're allowing yourself the opportunity to manage that complaint. The most important thing you can do is to manage that complaint, because you don't want to walk away, speak with a solicitor and sue you. And it goes in court, goes tits up, and you end up like Bob at the side of the road, destitute, cold, wet, homeless, no family, all because you didn't do it right. So the first thing as well is, if any of you are sole traders, I won't be a sole trader in what you're doing. I'll be a limited company. You need to limit the liability of anybody suing against you, so that in the event it does go tits up, they can only take the company off you, not your house and your family home and anything else you've got. You need to have a barrier between you and the people you deal with. Think about what I do. I don't repair vehicles that drive around with people inside them. I don't have the potential in the services I provide where somebody could get killed from it. I might give some bad advice and somebody might get sued from it, but that's about it. I'm a limited company. I have professional indemnity insurance. You might have two. You might find in terms of the insurance that you've got from a professional indemnity point of view, you might have limitations in the contracts as to what they might indemnify you up to. Doesn't mean you're not going to lose your home. If you do something that's defective and that car goes off the road and kills a load of people, it could just be, you might have repaired a previous total loss as an example, and it's not been repaired correctly. Somebody dies in it. Somebody sues you, that's it. If you're not a limited company, it's not just your house and your home and your wife and your kids and everything else for it. It's absolutely everything you've got. Probably, and they could continue to take money off you unless you declare yourself bankrupt for the rest of your life. Protect yourself. Put a barrier between you and who can sue you. You all work extremely hard for what you've got. Don't let people take it from you. Even if it is your fault and you have cocked up, still don't let people take it from you. Give yourself security. So somebody comes in and they're not happy with a complaint with something, and they want to complain about customer service or who they spoke to, what's been said. You put a documented process on your website to tell people what to do in the event of a complaint. You're now steering them to you, and you're taking them away from having the opportunity to speak with other people. The last thing you want is people, I've got a mate down the pub who told me this. I spoke to such and such. I know I can do this with them, sue them. You don't want that. What you want to do is, in the event that anybody shows any signs of dissatisfaction in any way whatsoever, you need to be absolutely all over it and control it and steer it and manage it. I've worked and seen so many repairers who have had people come in with a complaint and they get emotionally involved and they get upset, they get confrontational, they get very face-to-face, they get aggressive. In general, the people who do that are sole traders. The difference between a sole trader and a limited company is that every sole trader thinks all that money they've got coming in is their money. And you have there's a differential in that when you're a limited company, you're not. It's a company's money, not your money. So it allows you that distance between you and them. So you don't actually then think that somebody's trying to take my money off me. They're trying to sue me and get my money off me. It's not my money, it's the company's money. When you're a sole trader, it's not that. It's like they're out for something off me. They're trying to get something out of me for nothing. It's my money. You need to literally turn your heads off completely from that, because it will end up in court if you do at some point. You end up prejudicing what potentially you can do to manage a situation. So rather than do something where you do become confrontational, argumentative, upset, and it doesn't matter whether somebody's got a valid complaint or not, it doesn't matter whether somebody's having your leg over, trying it on. Every single customer that has a complaint, whether it's valid or invalid, you need to treat them the same. The first thing that you need to do is go, I understand that you're not happy. Please explain to me what you're not happy about. So you need to identify what it is you're not happy with. It could be something simple. You didn't ring me this morning. Oh, that's all right. I'm sorry. I apologise. Oh, that's fine. Great. Thanks, Tim. You've done an absolute shit job repairing your car. It's a death trap. Well, I'm really sorry about that. Can you show me what it is that you're not happy with where you feel it is a death trap? Show me. Two very different things, but all of a sudden you show an interest. So I'm not saying you're right. I'm not saying you're not right. What I'm saying to you is, show me what you're not happy with and allow me to investigate. What you then want to do is, so going through a scenario that you've repaired a car and you provide it back to the customer and they say they're not happy with the paint finish on the vehicle. And you've painted a full side on it. So I'll come in, sorry guys, I'm not happy with that. You painted my car, I'm not happy with the quality of the finish on it. How many variations is there in terms of not being happy with the quality of the finish of it? Is it the colour? Is it that it's got no depth? Is it because it's got nibs in it and shit in it and dirt in it? Is it got masking marks on it? You know, it's a whole different, you know, range of different things, of variations as to what the quality of finish could constitute under the Consumer Rights Act. So you're not happy with the finish in your vehicle. Can you specify exactly what it is you're not happy with? And can you show me? So make them point out what it is they're not happy with. When you're doing this, you want to be making a note in writing of everything they say and do and what they point out to you. Well, Tim, I can see there's masking marks on the back edge of that tape there. I can see that, you know, you've used a soft edge of masking for it. It's got overspray. It's powdered up the inside of the actual door apertures. I can see that when you painted the top there, it's got so much lacquer applied to it. It's got a slight run underneath that, and it's got some nibs on the back. No problem, sir. We'll sort it out. I wrote down every single thing that you're not happy with. I go through every single thing you're not happy with, and I resolve every one of those issues. You give the car back to the customer. Oh, and by the way, Tim, there's also a dent on the other side of the car. That wasn't there before it came in. Oh, I'm sorry, sir, but you raised a complaint. Did we not walk around the car and we evidenced all of the things that you're not happy with on the vehicle? Yes or no? Yes, I did. So I'm sure I would have seen that dent before, or that curved alloy, or that tyre that's bowled, or the petrol that was in the tank, or wherever it is, because we wrote down all of the things that you're not happy with, and you countersigned that to say these are the issues that your complaint relates to. Isn't that correct? So in the confines of the work that we've done, and our duties to you under the Consumer Rights Act and how we're handling the complaint, you've raised the complaint to ourselves, we've investigated it, we've identified that your complaint's valid, we've gone through this process of restitution to rectify it all. The area of complaint you're now raising isn't related to the work we carried out of the complaint, so not interested. You've stopped secondary complaints. So if somebody's having your leg over and they're going to keep coming back and back and back, unless you control them, they will do. So nail them at the start. Not arguing with you. You know, if you've got a complaint, come to us, tell what it is, show me everything, identify everything, specify everything, exactly what is it that you're not happy with. Okay, can you allow it? So a consumer issue in terms of communication. I'm not happy with X. I spoke with X person, they were aggressive, they were nasty, they were this, they were that. You know, if that's the case, careful in your wording. If that is the case, rather than, you know, we apologise, no. If that is the case, we apologise. Allow me to carry out my investigations. Do you know who you spoke to and what day at what time? Find out the details for it, evidence it. Once you've gone through what the area is, okay. So I fully understand you're really upset and you know, and you're crying, and you want, you know, compensation. But allow me to go away and investigate your concerns, because I want to make sure that if what you're saying is true, that it never happens to anybody else. Is it okay if I go away and do that for you? Well, I'm tying two things in there. I'm using emotional intelligence. I'm making them feel like I'm on side with them, but I've asked them, do you mind if I do that for you? So I'm helping you. I'm helping you. Well, no, I'm not. I'm just making sure I'm holding you off and I can go away and make sure that whatever you said isn't right. Because if it is right, I'm in shit. So Deb's just put something there. So what I learned from retail customer service, repeat what they say back to them to make them feel, I can't say the last bit, to make them feel heard. Yeah, spot on. And that's actually reaffirmation in it, and it is spot on because it makes them then think and understand that because you've then repeated it back to them, they hear their own voice and it revalidates it to them that you understand what their concern is. But all the time when you're doing it though, document it. So if they're saying verbally something happened, or an altercation or a verbal thing or a phone call, ask them, say, right, well, I'm concerned what will you allow me this opportunity to go away and investigate? You've done that, you go away and doing your investigations, it's a load of bollocks. They're just after a discount. Well, I'm sorry, sir. Well, what I've done is I've carried out this investigation. I've looked at what concerns you've had. I've listened to all the recorded phone calls, and I can't agree. The investigations I found that are carried out, I've actually got the recorded phone call here if you want to listen to it as well. I can say no issue whatsoever in how our customer service handler spoke to you. So I'm going to issue a final response to you. We work with X organisation who provide alternative dispute resolution. I can't see any potential breach of contract because it's over. You're just not happy how we spoke to you, and I can't say it's valid. So there you go. All right. Well, what do I do now? Up to you. If you can't sue us for anything, I've investigated your concerns. Other than investigating your concerns, is there anything else that I could do to help you? Oh, I'd like a bit of a discount. No. Wasn't a valid complaint. No. End of conversation. Stumps them. So they just go away then. If they have got a valid complaint, I'll carry out my research, my investigations. I'm going to write to you to address your concerns. The first concern you raised was X, this person was rude or abrasive to you. The second concern was this. Okay, so the concerns that you've got and the investigations I've carried out, I can see that your concerns are valid and I don't hold the complaint you've got. So on a without prejudice basis, I'd like to offer you some type of compensation. Could I offer you money? Could I offer you a free service? Could I offer machine polish in your car? Is there something I could do that would make you feel better? Oh, right, I wasn't quite professional, that. You're only a small one-man body shop and you've gone away, you've done everything. You've gone away, investigated it, researched it, you offered compensation. Just, wow. I was just having a bad day and it just pissed me off because it just upset me. No, we understand that, but we pride ourselves on the quality of communications we've got with customers. From a customer service point of view, we don't want any of our customers to be upset because we care about you. Do you know what, actually? Just based on the way you've handled this complaint, I'm going to come back and use you again. Just turn a customer around because they now find that you understand and appreciate the value of their custom because of the quality of the service you've done with it. Value makes them feel worthy, makes them feel that you care about them. And that's the most important thing you can do with the customer. Now, in the event that you've gone through this process in either whether it be through a communication issue or whether it be to do with the product issue or the services you provided, the actual repair, identifying all the things that they're not happy with, and you say, well, can you afford us this opportunity to rectify the vehicle, the issues you're not happy with? And they say yes, and you still cock it up, and it's worse, they might arrange for an independent engineer like me to go and inspect the vehicle. Now, the worst case scenario is it ends up in court, and there's certain protocols in court that need to occur. So if you were to sue a body shop for defective repairs, you might want to have an independent expert witness to inspect the vehicle. But if you're going through a court process, you have to apply to the court for permission to do so. So if somebody off their own back instructed me to inspect their vehicle, And even though I then do a report that satisfies the criteria under the civil procedure regulations to be admissible as evidence in court, it doesn't necessarily mean that it'll be allowed admission, because the person suing the other party might not sought the attention or permission of the court to do so. The alternative of that is also true, or the opposite of it. So if you as a repairer arrange for an independent engineer to inspect it and say, we want to cover our backside here, so we've got an independent expert to assess the quality of repairs to say whether it's fit for purpose as described in merchantable quality or not. Again, just because you've done it and you're covering your backside with it, it might not be admissible as evidence in court. However, it always pays, to apply due diligence in the process of, should something go to court, you've got something sat there in the background. So from either a consumer's point of view, I'd be saying you need an independent engineer to inspect that vehicle before everybody else touches it and have it sat there. As a repairer, if you're confident that that vehicle's been repaired correctly, I'll be arranging for an independent engineer to inspect it, just so that you have it sat there in the background. Now, within a complaint where parties don't agree on either the complaint or the resolution, it's then what other courses of action are available to the customer. So you've investigated the complaint, you've either said it's valid or it's not valid, and you've issued a final response letter to them, and they're now looking at a means of restitution. So by saying restitution, I mean either legally through the courts or by some other alternative dispute resolution service. So ADR is an alternative to the courts where each party submits their evidence and an independent arbiter looks at the evidence provided to work out where they can mediate between parties to seek resolution. If both parties agree, it becomes legally binding. If both parties don't agree, it doesn't. They can still go to take legal action. So if you accept the findings of an alternative dispute resolution service, and they have to be registered as being an ADR, then you can't have two bites of the cherry. So there's certain organisations in the industry, might be through, I can't remember the IMI do it, but I think the MBRA do it. And there's also other organisations where they are ADR providers. If you're a small body shop, probably doesn't matter that much to you. But if you're a large network of body shops, then I would say it would be best if they were linked in some way to an alternative dispute resolution service. Now, the difference between ADR and courts is that generally with alternative dispute resolution services, the body shop would pay a set fee, whereas with a customer, they might either pay a small fee or no fee. If you go to court, it's expensive. Well, what you have in court is that where a claim is less than £10,000, it falls under the remit of the small claims court. In the small claims court, now it can actually stretch up to £20,000 depending on the case, but generally it's less than £10,000. In the event where you've got a claim for less than £10,000, because they want it to be cheap to both parties, each party has to pay their own legal fees. Now, that means win or lose, you will have to pay the legal fees of the person you've instructed. Now, in the small claims court, it's actually not as complicated as what it is in the higher courts. Or, for example, if you go on claims online. So, if you do something where somebody's seeking legal action against you, or you're seeking legal action against somebody else, then the courts will help you through that legal process, either in the documentation that you need to serve and fill out, or also in terms of the documentation you need to fill out in defence. So If you haven't a clue what you're doing, the courts and the people who work in the courts will help you. So don't be scared of going to court. So they're not fantastic places, and they're terrifying the first time you've done it. But once you've done a few, then they're not scary, because all you need to understand is the process of paperwork that goes through in terms of how you raise a claim and how to process it. So as long as you do as instructed, then it's fairly straightforward. If you're actually instructing somebody to act on your behalf by way of it being a solicitor, and very rarely in these type of cases would it be a barrister, because it'd be a direct access barrister and they cost a fortune. I said, even if you're successful, you might find that you still have to bear your own legal fees and they bear their own legal fees. What you can also find, though, is that in the event that you're successful, sometimes a judge might award some type of conditional fee arrangement or conditional fee payment or compensatory payments towards the action you've took. And it also depends on whether the party defending the case, whether they've acted reasonably. So if, for example, it was like I was suing an insurance company and they were just defending it to be arses and they should have settled outside of court, then a judge might award punitive damages because it could have been resolved without going to court. So ironically, the whole point of the courts and all the court wants is for you not to be in court. So what process did you go through to avoid being in court? Oh, I have a complaint process. So what happened as part of that complaint process? Well, we documented in evidence what the concerns were of the customer. We investigated them. Some areas we agreed on, some areas we disagreed on. This is what we offered. We provided the opportunity to rectify the vehicle. They denied us that opportunity. You know, we could have got it repaired for X, but they went off because they weren't happy with it and took it somewhere else. We offered compensation, or we offered to do this. Each and everything that we offered was dismissed. They just wanted to sue us completely. And a judge might look at all the evidence and go to the consumer, why didn't you take them up on the offer? You know, they've been reasonable with you. Can't stand them. Well, if a customer's lost all faith in you, there is a bearing there where legally they can say they've got an entitlement to seek rectification from the work being somewhere else. But if it is something where it's not rational or logical, a judge might go, well, that's, you know, I understand you're not happy with, but you still need to afford them the opportunity to rectify it. Should they have not done it right then, by all means, then you can sue them. But actually, as part of this conversation, they actually offered you a full refund, didn't they, Mr. Such and Such? Why didn't you do that? Well, I wanted to make them suffer, take them to court. Really? All right. And I hear that a lot. You know, these bastards have done this to me over here. I'm going to make them suffer. I'm going to drag them through the courts and make them suffer. And the judge goes, really? Right, I appreciate you're not happy with the repairs, but you want to drag somebody through the courts to make them suffer. Well, that isn't what we do. We just look at things on the bounds of, can you reject goods and services under the Consumer Act acting with a fit for purpose as described in merchantable quality? Yes, you've got a case with it, but you don't need to, you know, smack them to pieces with a big stick and shoot them and then try and, you know, drag them through the courts, do you, Mr. Such and Such? You could have probably resolved this without going to court, couldn't you, Mr. Such and Such? So actually, I don't think your behaviour is really fitting for what you've done. So we're not going to find in your favour, even though your complaint's valid. I've seen that. So all the time, from whether you're a claimant or a defendant, you need to be working towards a resolution. So as a business, you want to be doing every single thing you can do to sort that problem out before it goes to court. Avoid it at all costs. When it then gets to court and a judge says, so what actions did you take, Mr. or Mrs. Such and Such, in resolve, you know, as a means of seeking resolution as part of this complaint, and you show them, all right, that doesn't come across as a business that's been argumentative, obstructive, dismissive, and didn't want to resolve your complaint. If anything, it looks the complete opposite. So did you do anything other than those things? Yeah, we also advise them it can go to an alternative dispute resolution service, or, you know, we actually give him links to citizen advice if he's unhappy. We even told him, like, you know, if he did want to sue us, we've actually made him aware of who our solicitors are, so we can put instructions against them. All right. Right. Okay. Mr. Such and Such claimant, you know, why didn't you take them up on in the office? Just wanted to make them suffer. So judges will look at that and it just instantly turns them off. Now, if you've gone through all of that and you've got all this evidence there, and the person suing you doesn't accept it, and it went to court, and the judge says, like, okay, so you've been offered these things, why didn't you accept it? And I say, well, I arranged my own engineer to inspect this vehicle. The faults that were found on this vehicle were these. I did seek permission initially for the court to allow this evidence was submitted, and it was denied. However, I think it'd be highly beneficial if Your Honour saw this information. Do we have permission to give it to the attention of the courts? Oh, right. So, Mr. Kelly, you've told me you've got a report here. We weren't aware of that. Does it document and evidence the defects that you've identified on the vehicle? Yes, it does. Does it actually quantify the cost of rectification? Well, yes, it does. So when X garage offered you £2,000 as restitution and you told me you didn't accept it, what was the cost of rectification on your report? It's £30,000, Your Honour. That's why I didn't agree with it. Oh, right, okay. Right, I can see why you wouldn't accept these offers by this body shop, because it doesn't come across as being quite fair, that does it? No, it doesn't. So all the time, having something in the background is good because it helps your defence in either way, whether a consumer as a defendant or as a claimant. The judge then would look at all the evidence available to them on the grounds of what is fair and reasonable, because we're in a small claims court, to work out the best means of who would he find in favour of. Once you get out of the small claims court, it goes out the realms of probability, fair and reasonable, to what was contractually agreed, what was the expectation. But once you get in the higher courts, it changes completely. And it's not on the bounds of fair and reasonable and the bounds of probability. It comes down to a matter of fact. Matter of fact and what's been evidenced, and that's then where an expert witness report comes in. Okay, so on that note, I'm going to ask if any of you got any questions, and it'll give me a breather to get a gob full of water. So if you all want to unmute yourself, and have you got any questions so far? Richard keeps disappearing. Well, yeah, he's back again. It's like, where's that handsome bugger gone? Oh, there he is. And what's even funny is the fact that the cursor's turned to a hand shape, and every time Richard coughs, I can put it over his mouth. Right, go on to questions, please. Or actually, so Clint, was it yourself? He said he'd gone through court this week. Who was it who said they'd been took to court?
Yeah, that was me.
Kirk,
Last
go on,
week, a week ago today.
So,
What happened with mine, it was slightly different to what we were discussing. That's why I haven't spoke yet. So I did an estimate, a written estimate. It wasn't signed, so it wasn't classed as evidence, apparently. And the customer shook hands on doing some extra work. We did some extra work, which was about £3,000 on top that wasn't originally estimated. Cut a long story short, he never paid it. We had a disagreement. He ended the contract. I spoke to a solicitor, and they said you can only get charged what you've estimated. So we charged that. It went away. Excuse me, I'm full of cold. About 4 or 5 months later, I get a small claims letter through the door. He'd been and got some other work done, and obviously pulling us to bits. It's echoing like mad. And trying to get us to pay the other bill, basically. It's funny how you mentioned about how the courts want you to sort it out, because they really did, but it was me that was stubborn because he told so many lies. And we've been to court, basically, and the I estimated another 1,500 quid on the job to finish it, and they've made us pay his costs, and all that type of stuff. Really, it's a bit more detailed than that, but that's just a brief of it.
Yeah.
It got a little bit messy as well with some statements, and apparently I tried to steal the vehicle and all sorts of stuff, which was all false. But it did turn really messy. When I say messy, they just, once you fall out with a customer, they'll say anything, you know, and I mean anything, to the point that he was saying that I'd been around his house and all sorts of stuff, which was all false, you know. But obviously the court sided with him because our paperwork was fucking shite. Excuse my language.
Yeah. So, from what I've explained in tonight's session, had you have known what I've told you tonight, do you think it might have had a different outcome?
I've been doing this 25 years and I've only ever seen 2 complaints. And as you said at the beginning, you don't know that it's going to happen until it happens. And I've heard about things happening, and I've always sat back and thought, well, the body shop must have done something wrong. And, you know, there can't be a grounds for complaint without having grounds. I've always thought that in the back of my head until you meet that one person that literally wants to destroy you. It's all in the area. I mean, he's just literally trying to destroy us. Luckily, we've had some people reach out to us that he's done this before to another garage. I got a statement from the other garage. It was a mechanical garage. Obviously, we're a body shop. He reached out to us. We got a statement via my solicitor about that, but the court wouldn't hear it.
Yeah,
they wouldn't accept his statement. It was all bullshit, if you want the truth. And this was all over $5 grand, and it's cost me 11.
Yeah,
that's where we're at. So
going back to what I said then, so had you had tonight's session earlier, now knowing what I've gone through tonight, do you think the outcome would have been different?
100%. I mean, even now I know what I know before this session, I've got 2 pages of bullet points here.
Yeah.
From just tonight, you know. It's time to change for us, unfortunately. Well, not unfortunately, fortunately, you know.
Yeah, you need to be. Everybody needs to be professional. Yeah, you can't afford to run a business not like a business. And unfortunately, every single body shop I know, barring very, very few, don't. They're all crap. And they just run it because they've gone from being a panel beater, painter, or MET guy to then working on cars to it's what we do. You can't afford to. Your businesses. And the thing is, you've got the Consumer Rights Act, which tells consumers that so every person you're dealing with is a consumer, in essence, unless it's a corporate entity.
I haven't read the. Sorry, go on.
Yeah, and they're protected in law. It's simple as that. So, and the instant they've got a right to reject goods and services, then you need to be sure that you comply with law. And the premise of contract, what's been offered, accepted, and agreed, unless you can document it in evidence, then in general, a judge will look at it on the viewpoint that you've harmed a customer in some way, because otherwise the claim won't be raised. So there's always a bias at the very start, whether it's conscious or unconscious, from a judge that they'll want to find in favour of the customer because it's the customer raising the complaint. So you need to protect yourself from that, and you need to do it right from the very start rather than catch it on the back foot.
Yeah, we've learned that now, to be fair, quite drastically, but you know.
Yeah, you've got to make sure you've got written processes down and have contracts in place, and then people sign to it and accept it and agree.
Well, I'll be completely honest. I had nothing other than estimates. Apparently, an estimate's the same as a quote unless it's signed and delivered correctly. It's a scope of work, how they call it, isn't it? So, one of the things that I learned, you mentioned at the beginning about your scope of work. So, on that particular job, we're painting the 2 front doors black on the insides and outsides, but the customer was carpeting the side door and the 2 rear doors. But on my estimate, I put paint doors black, but we only painted the outside. Because on your scope of work, you put doors black, unless you put not the interior or not the inside or whatever, you're liable to paint the full lot.
Yeah. Oh, there's all sorts of stuff. It's things like, I'm hoping you all know, but so do you all know what metameric is? From a paint side of it. So metameric is where, certainly on vehicles that are red, where due to the UV rays on it, it alters or discolors the paint. And one of the funniest things I've seen from an insurance company's point of view, and it tickled me no end, because I worked for an insurance company. Yeah, I worked for an insurance company. I just wondering whether I was still recording or not then, and just being careful what we're saying. I mean, I am still recording, so I won't say it is. I worked for an insurance company, and I acted as a technical expert for the network of repairers. And this repairer was sent work from the company I work for, and the whole car was pink, and it needed a new front wing and a bonnet on it. Or was it actually? Yeah, it was. It was new front wing and a bonnet on it. So this body shop, being a smart ass, painted the front wing and the front bonnet exactly as it would have come from, like from the manufacturer. However, because the rest of the car was pink, and the bonnet and the front, and the wing were absolutely gleamingly, beautifully glossy in a bright red, customer comes to collect it and just goes, "You need to paint the rest of my car because it's clearly identifiable that the vehicle's been accident damage, it's been repaired. So you need to reinstate me back to how it was." So the body shop contacts me and says, like, "What do we do? So do we repaint the rest of the car, or do we tell him to go away? Because we can't put him back to how he was, because we'd need to give it like a million rays of sunlight onto the bonnet and the wing to make it go pink again." So what I actually said to the repairer was, really, when the vehicle came in, you shouldn't have touched it. Now, there's a person on the refinishes crew who blocks me. And the reason why he blocks me is because I acted as an independent expert witness on behalf of the claimant in a case where he was the defendant and he carried out poor repairs on the vehicle. And as a result of that, and it went to court, the court found in favour of the claimant and not him, and he lost. So he's upset with me because he feels that some way that I'm at fault for him being sued for 15 grand. Now, I actually felt sorry for him because in the process that he went through, what he should have done right at the very start was actually told the customer he wasn't going to touch the vehicle. Because a lot of the issues came out the fact of, yes, it was linked to the work that he did, but it was also because of the work of people who'd worked on it previous to him that was substandard. And because the work that they did was substandard, and then he tried to rectify it afterwards, so basically just stuck, he put the most amount of filler on a vehicle I've ever seen in all my life. It was just like bonkers. Never seen anything like it. It was laughable. To the point of, he must have had like 3 foot wide panels to slap it down the side of his camper van. It was just like, and what had happened with it was corroded to pieces, this camper van. It went to another company to have new panels put on it, which they did. After these new panels had been fitted to it, it then went so part of it was down to the customer. It went and got sandblasted. And I'm like, why would you sandblast the vehicle after you put new panels on it? So then the company where they did like the media blasting absolutely annihilated this thing, and all the panels were distorted. So then this poor guy then gets it in to make this vehicle into a show-winning vehicle, which is what he told the customer, and as advertised on his website, when really what he should have done was, listen, because of the people who've worked on that vehicle prior to me, I'm not going to touch it. Absolutely not. Because I can't meet your expectations. And certainly I can't meet your expectations for the sum of money that you're going to pay me. However, he didn't do that. And he's clearly a nice bloke and he did what he thought was best. But because he didn't have a documented contract in place setting out the expectations to the customer, the level of work being carried out, and the money's being paid for it, he positioned himself in such a situation that when he couldn't carry out the contract as he described it to be for the money that he was getting paid and the works were defective, then it then meant that the consumer had a valid case against him. So again, there's times you will find in the works that you're carrying out, when something comes in, just because you think you might want the work doesn't mean you should do it. So unless you can fulfill your obligations under the 2015 Consumer Rights Act to make sure that the vehicle's free of defects when you give it back, it's fit for purpose as described in Merchantable Quarter, and that you carried out that work with due care, skill and attention and diligence, don't do it. No, there's some best not to repair as well as repair it.
My issue was I couldn't prove what we'd agreed at the beginning.
Yeah.
That was it. So his scope of work was, he just extended it and extended it and extended it. And I was like obligated to do it because I couldn't, right at the beginning, I didn't have a contract in place to say we're doing X, Y, and Z.
Yeah.
So he just exaggerated it on. We did half of it. And then it just got to the point where it was taking the mix. So I said, don't think so, not going any further. Yeah, went to court and yeah, I was obligated to finish it basically.
Do you know what makes me cringe more than anything else? People having something come in and then the person there then saying, whilst it was in, and the guy was after some type of discount, then I offered to do X on it as well while it was in for free. Potentially, whatever you do as an extra doesn't absolve you in any way from the Consumer Rights Act. The instant you touch it and work on it, you're liable for it. So I've heard from a body shop that whilst it was in, as a gesture of goodwill, because they wanted to make a nice job out of the car, they touched in stone chips because they thought it was a nice thing to do because, you know, the rest of the car looked great and the stone chips made it look bad. The customer complained that the repairs haven't been carried out satisfactorily because they've not repainted the bumper, repainted the bonnet. So they went, yeah, but you've not paid us to repair the bonnet. You know, we just thought because it needed touching up, we'd touch it up for you because we still had some paint left over from the mix we've done. We just thought it'd make it look right. No, not a satisfactory quality that. Sued them. They just told him to trot on. You're having a laugh. You're not paid us to do it. You can't sue us something we're not agreed to as part of the contract. Went to court. They lost. No, if you're carrying out works and services, whether you charge for your services or not, there's still a valid contract in place. So you still carry out that work to an acceptable standard. So if you are going to do something extra out of the goodwill of your heart for a customer, I would make them aware of it before you do it. So I'll ask Richard this question because he's a knowledgeable man. So in that circumstance where somebody took you to court for touching up the bonnet on a car where you've not been paid for it, if you wrote down in contract that you're doing it as a gesture of goodwill, would you see it that they could seek rectification cost off you?
By touching it up without their consent, you've committed a tort against their property. So you've already failed. Whether your objective was to make it better is irrelevant. You have committed a tort. Simple.
Yeah. So what then if you sought their consent? What would your viewpoint be?
Well, that if they consented to you touching it up, providing you've described and explained and got documented what that process will be and what the expectation is and what the end result is, I wouldn't be doing it. But you've potentially got some sort of ability to have a contract that you could defend if they sued you, but you're getting into messing about with stupidity.
Absolutely. And it's the other side of it as well, then, is that without that contract, it's very subjective, isn't it? So like you say, like you've got a friend who's a judge. From a judge, how a judge will look at it in terms on the bounds of probability, without it being documented, it's very ambiguous, isn't it? And certainly from a judge's point of view as to what's been done and described, or no, it just leaves you open, doesn't it, completely?
We work on a different sort of level of car because all of our stuff is exotic supercars, but we won't replace a screw that is missing without them being notified, because we might be doing something that is going to cause a problem. And a typical thing was with a Ferrari 355, they had screws in the bottom of the door card. Quite often they were missing and the bottom of the door card moved about. But you go and put a screw in there and it falls out and it scratches the £2,000 carbon fibre kick plate. So you don't put a screw in to anything for any reason without their consent.
So if all you want to take something from that, don't do anything to a customer's car without their consent. Don't do favours. The biggest thing I've learned about the motor trade about people doing favours is it's never a favour. It will only ever get used against you to spank you on the arse. Don't do it. Pretty much. Right to reject goods and services. So what you need to also understand is the fact just because you're repairing a car doesn't mean that the customer can't go away and request a full refund from you if it's got a defect on it. Now, what they have is they have an automatic right to reject goods and services in the first 14 days, as long as that vehicle has evidence of being defective, or being defective in some way. They always have the right to request you to rectify it. Alternatively, they could ask for some type of discount. These rights then go for the first 30 days, it's still the same thing. Up to the first 6 months, the duty lies on the person supplying the goods or the services to show that the fault wasn't there at the point when it's passed over to the customer. So you have to prove that it wasn't faulty. After 6 months, that duty then changes towards the customer. They have to prove that it was faulty. So with cars, it gets into a complicated area when you have paint reactions, or you might have it where somebody's put a car cover over a car and it's breathed and it's got bubbles under the paint. Or it could be some type of chemical reaction under the paint. You know, some of these things might not be patently obvious at the start, but they might take time to come out. So from a consumer's point of view, so if it was in the first 6 months, you need to prove that it wasn't there. Well, you're kind of pretty shafted, really, because if it's there and it's there within the first 6 months, it's there. You know, so it must have been something you've done that's caused it within that process. The chance of it being anything that, you know, that it's not that you've done, pretty slim. So there might be something that you've done and it's just random chance and it's something else in the background. Like I said, it could be something like a car cover where somebody's thrown it on and you think it's something you've done when it's not. So I've seen that with the body shop that I do work with. However, in general, if something presents itself, you know, you need to be really being switched on and thinking, I need to get hold of this pretty quick. Because, like I said, a judge would look at it on the bounds of probability. You know, have you caused the issue or not? Well, if it relates to works being carried out, the potential is that more than likely it is. So control it. Just get on it as fast as you can, get it in as fast as you can. And even when you're uncertain, if you're being afforded the opportunity to rectify it, do it. Might cost you money. But this is also the reason why you need to repair the cars right first time around. Don't have any complaints. And it's why I keep banging about on, putting things on, like I said, like with the refinishing side of it and the blending and stuff with it. And, or talk about quality repairs or masking ones is other things. Seeing cars masked up drives me crackers when they, strip it. Do a decent job. Because don't ever put yourself in a situation that affords a customer the opportunity to sue you or get something out of you. So there was a case I dealt with this year. The vehicle was repaired through an insurance company at one of their approved repairers. The repair cost was £6,800. Due to them carrying out defective repairs, the vehicle's now gone to a main agent and I've been acting on behalf of the client. And the rectification cost on it is £22,000. So the original approved repairer, not only will they not be getting paid by the insurance company for the repairs they carried out at £6,800, they'll get a bill for £22,800. Just because they didn't do it right. But also because the customer service handling was absolutely crap. Look at Deb's husband's face, you can tell he's been working late, can't you? Yeah, that's a late night. So yeah, now the thing is with that particular case as well was that there's bits where in certain situations, in certain environments, you might see certain behaviours occur. Other times it's blatant stupidity. And then if it's not blatant stupidity, it's absolute arrogance of whereas, let them sue us. In the realms of insurance, it's very rare that you'll find a customer sue an insurance company because of the cost involved for it. And I would suggest that probably the only ones that do are the ones who instruct me, come through me. And I don't really sue that many people, but I'm not scared of doing it. And the thing is with insurance companies, and the amusing side of it is that because nobody ever sues them when you do, it scares the absolute living daylights out of them. Because they're going like, well, if you're not happy, you can do this. No, I'm not going to do what you want me to do and go through the ombudsman. I'll just sue you, breach your contract. And all of a sudden, they're like, we've just got a letter from his solicitor, you're suing us. Yeah? Why are you suing us? You told me to do so. Well, no, we told you could do that. No, you told me if I can either go through the ombudsman or I can sue you, so I'm suing you. Well, we'd rather you didn't do that. Well, I did reach out to you originally for you to actually resolve the situation without any needs for litigation or alternative dispute resolution or through an ombudsman. I provided you that opportunity, and through absolute sheer arrogance, you told me to trot on. The Foxtrot Oscar. So I did. So tough shit. So now what you're going to find is it's going to cost you about 150 grand this case. You could have sorted it out with me if you were being civil over the phone. It's really interesting how fast people change their behaviour when they work for an insurance company, when they realise all of a sudden it's going to cost them 150 grand. They bend over backwards and sort something out really, really quickly and get things resolved. Because they don't like litigation. They understand courts are dangerous places. So, as an interesting one, Richard, it's like that Ferrari Inter that I did for you, where the insurance company were absolutely not playing ball whatsoever with it in terms of wanting to authorise repairs on it. And Richard is, out of the people who are involved in the refinishers crew, he's quite litigious as well. So if you don't know what litigious means, it means he likes suing people. So he's not scared of taking people.
I don't like suing people. I don't.
Right.
But I'm not going to back down. And insurers right now want to be sued, but I would not advise anybody going to court. The only people who make money by going to court are solicitors. My brother's a solicitor. He makes lots of money. I don't.
Yeah. In fact, actually, Richard's brother, who's a solicitor, doesn't even do favours for Richard, even though he's brother. So if Richard's own brother won't do him a favour around litigation, don't do a favour for a customer who wants a bit extra on the car. If there's a parallel for you.
His wife was in an accident. I'm dealing with the litigation for that. He won't touch it. He won't get involved.
Yeah, conflicts of interest. So I've got some interesting cases going on today, actually, which have been quite funny. But, oh, which reminds me, Richard, I should probably stop recording for this one. When I told you about Ratarossa, he's going to chat with you.
Yep. Yep. That'd be good.
Yeah.
Really kind.
So he'll definitely be all over that one. I'll explain to you after this call later on.
Yeah.
Cool. So, rights to reject. So we'll be winding up fairly soon. So we'll get into the last bits of it. Your short-term right to reject. So I said the dates that you need to be aware of are within the first 14 days, first 30 days, and 6 months, where all of the duty lies on the trader to make sure, or to prove that the fault wasn't there at the point when the car was delivered, and that the repairs carried out aren't defective. After that point, it's down to the consumer to prove that they were defective at the point when it's given to them. So when a customer exercises those rights of rejection of goods, the trader's got a duty to give the customer a refund in full. So the element of contention then comes down to, is the complaint valid or not? So if that customer's got a valid complaint and the repairs are defective, you need to give them a full refund. Simple as that. Customer's happy. You're not so happy because you've lost out on the job, and you give them the money back. So they've got, they might have a car repaired kind of all right for free. You don't want to be doing free work as a body shop, as a repairer. You're making profit. So make sure you've got a contract in place that defines the terms and conditions of that contract and set the expectations of the customer, defining what the actual schedule of work is. Interesting areas are where parts are defective on a vehicle. So if they are, is there a duty on the customer to actually return the goods that are defective if they're getting a refund? Well, actually, yes, they must do. But the trader must bear any cost involved in that rectification. So an interesting part of that could be where a customer actually complains about defective repairs. Any cost incurred in rectifying that vehicle, you're liable for. So if it's movement of the vehicle from their house to your house, you're liable for it. If they went to get an engineer to inspect it, and on the basis of that engineer's report, it evidences what's defective, and you're agreeing to take it back in again, you're liable for those costs. So basically, any cost borne by the customer which substantiates the fact that you carry out defective repairs, you're liable for. So part of this comes under the bits under the Consumer Rights Act. Like I said, it's massive to go through all of it. I'm just trying to keep it succinct. You'll find the areas that are relevant to you related to motor vehicles under Section 48. And it defines what a motor vehicle is and what services are carried out. But that pretty much covers in terms of, it covers what is a vehicle, what works might be carried out. And you'll see things within the actual Consumer Rights Act which are directed more to mechanical repairs and body repairs. However, the same applies in both. So whether it's referring to some type of services work being carried out or maintenance, what is covered in the Consumer Rights Act will apply just the same to a body shop as it will to a mechanical workshop. So if it was, as an example, somebody part exchanging their car, and the car you bought is defective, under the Consumer Rights Act, that dealer should either give the car back or financial compensation at the value of the vehicle, which is something that most people don't know. Anybody buying a used car from a dealer I will guarantee you that any deal you deal with won't want to conform to the Consumer Rights Act. They never do. But one of the companies that I deal with is a guy called Ian Ferguson at Reject My Car. We pass work between each other. And some of the stories I get from him about vehicles being bought that are defective and then the dealer trying to have the customer's pants down, the Consumer Rights Act, absolutely horrendous. They're always trying it on. So as an example, you can't charge a fee on a customer in respect of a refund. So you can't go, yes, you've got a valid complaint, I'll give you all your money back by hour. However, there's an administration charge of 100 quid for us to do so, which again is what some type of dealers try to do. So an area where you might need to look at that relates to you guys is where customers paid an excess. So if you carry out work on a vehicle and as part of an insurance contract, so they're saying the customer's liable for the first part of it, whatever the excess is. If the vehicle isn't free of defect at the point where when you're delivering it back to the customer could then argue that they're not paying their excess because the contract hasn't been fulfilled. And they would actually be in their entitlement to reject it at that point. Now, other areas of ambiguity are where a customer takes the vehicle under distress and says that I'm not happy with the vehicle, I am paying the excess, well, under duress rather than distress. However, I am rejecting it. So to make sure a contract is fulfilled, it means all parts of it have got to be filled. So you might not have obliged your contract in repairing it correctly, but because it's offer acceptance and consideration, if they're leaving the vehicle with you, they can say we're not paying their excess, but to take it away, to make sure that contract's fulfilled, they should really pay the excess. At which point, then they've fully fulfilled their duties under the Consumer Rights Act. They've said, well, I've done my bit. The only bit that hasn't been fulfilled is a breach of contract. Now is you do defective repairs. So from their point of view, when they raise that with an insurance company, any rights and obligations of that contract they've got with you, if they've satisfied it, everything, they've done all they're required within the contract. In the eyes of a court, if you've done something defective, customer said, well, I knew it was going there, I paid my bit for it. The invoice has been paid, but it's a breach of contract because the repairs are defective. It then puts you in that situation where you either need to rectify it, refund them in full, which could be an interesting one with an insurance company when they paid the bill. So do they refund the insurance company, or because what you've got there is something called a tripartite contract between the body shop, the insurance company, and the consumer. So this is one of the reasons why insurance companies don't want to pay you up front. They might say 30 or 60 days. Most of the time they're doing that just to make sure that they don't get bit on the backside for defective repairs. And why they do it. So just going to get back into my share screen and make sure I'm on the right bit. We'll wind up in a few minutes. So as an example, where you have took some type of payment and it's not going through an insurance claim. However, that customer's paid you, you need to refund them by the same method. So if they paid you in cash, you need to refund them in cash. If they paid you by a credit card, you need to refund that credit card. Unless the customer expressly agrees to it otherwise. Unless you mustn't impose any type of fee on it. I'm just going to go to my next page. I'm just going to try and find something. So a partial rejection of goods, like I said, they could actually request a discount. And then these are your time limits. So as I said, consumer's got a short-term right to reject losses. If the time limit for exercising it passes without the consumer exercising it, or unless the trader and consumer agree that it may be exercised later on, these are the specific times. So like I say, it's first 14 days under most stuff, certainly under distance selling regulations, if you're buying a product over the internet, you've got an instant right to request a full refund in the first 14 days. And again, under distance, here's an issue as well that can be an interesting one, is that if you agree to repair a vehicle on behalf of a customer and all the communications are by way of phone and they don't come on your premises, you pick the vehicle up from their house and deliver it back. One aspect of law you might not realise you're entering into is under distance selling regulations, which again gets into slightly different areas under the Consumer Rights Act. So it's just something to have on your radar, but it's certainly something that affects. So anytime you collect a hire car, for example, if you're a customer, that's the reason why they'll always try and get you on site in their actual office rather than doing it from home, because your automatic right to reject goods and services and have a refund in the first 14 days. Because the last thing you want to do is agree to repair a car, and because you don't understand distance selling regulations, and then them try and ask for a full refund just because they're not happy with the colour of it. Which would be an interesting argument. I might ask Richard on that one later on. So, under section 7, so if goods supplied by the trader in response to that request or agreement don't conform to the contract, the time limit for exercising the short-term right to reject goods and services is either 7 days after the waiting period ends, or if later, the original time limit for exercising that right. So generally it's 14 days. So the next one past that is 30 days, where you need to give a refund where it's defective, 6 months, and then 12 months. Right to reject repair, right to repair or replacement. So this section applies to a customer's got the right to repair or replacement under section 19, 3 and 4. If the consumer requires a trader to repair or replace the goods, the trader must do so within a reasonable amount of time. So one issue I see a lot on the mechanical side of it is where repairs have been defective, and then the garage says, "Oh right, we'll put you in to get it rectified again," and it might be 2 or 3 weeks later, and it's like, no, absolutely not. Under the Consumer Rights Act, really what you need to be doing then to rectify it is you need to get it in straight away. So if you don't rectify it in a reasonable amount of time, you're then giving the opportunity to a customer to go away and get it done somewhere else, because you won't be fulfilling your duties under the Consumer Rights Act. And then as a repairer, you also would be bearing any necessary cost included in doing so. So including particularly the cost of any labour, materials or postage. So if they're having to communicate with you by certain means for you to rectify it, you've got to bear those costs. So the only time when a consumer can't require you to do that is when it's not possible to rectify it. So it might be that the parts aren't available, or whether the actual means of rectification they're seeking is disproportionate compared to other remedies. So I can't ask the whole car to be repainted if it's just the defective, paint on the front wing, as an example. It might be slightly different colour, or a nib or something else like that, So whatever they're seeking as rectification or as a remedy always has to be proportionate. So any question as to what might be a reasonable time period to rectify it is based on whether it's a significant inconvenience, is to be determined by the nature of the goods or the purpose for which the goods are required. So if, for example, a full restoration had been done and it's defective, however long that took, if it's being rectified, it'd be reasonably thought that it might take longer again to do it. If it's something where something's just been, it's got a run in it, or something's defective, it might take, an hour or a few days. So if that vehicle comes back to you for rectification and you take weeks to rectify something that should have been done in a day, that would be deemed to be unreasonable. So it always comes down to what's a reasonable idea of a time period relative to the work that's been carried out. So a consumer who requires or agrees to repair of goods can't require the trader to replace them or exercise their short-term right to reject without giving the trader a reasonable time to repair them. So you've also got the opposite as well. So I can't insist that you get it in right now and do it right now. If you've got work coming out of your ears and you've only got 2 people in your garage and it needs 10 people to normally operate, or you're ill, or you're on holiday. So there's certain things a consumer can't do or insist on. There always lies a duty on both parties to be reasonable in what they're doing. And then you've got a right to a price reduction to require the trader to reduce by an appropriate amount the price the consumer is required to pay under the contract, or anything else if the consumer is required to transfer under the contract, or to receive a refund from the trader for anything that already paid or otherwise transferred by the customer above at a reduced amount. That kind of relates to tradings on new cars. But if you've got a walk-in job and you've done something defective on it, if you've not conformed to the contract, if you agree a discount with the customer, document it, evidence it, and then that way it can be shown that you've tried to resolve the situation, but it also limits the customer from taking further legal action against you. So I'm going to come out of that lot. Just check it, make sure I've covered everything, which hopefully I have. Right, so I'm just going to stop screen sharing. And then I'm going to give a brief synopsis about alternative dispute resolution. And then just open it up for questions before I finish for the evening. Yeah, so I've covered the things that I wanted to in terms of the Consumer Rights Act. So bearing in mind the contract you've got, what customers can do, and the fact they can sue you, they've got alternative means of seeking resolution. So with insurance companies, they always refer you through to the Financial Ombudsman Service. But what they do is they're an alternative dispute resolution provider. So they should look at all the available information, and based on that, on the bounds of what they deem to be reasonable, come to what they believe is the best outcome for the customer, or actually advise whether it's a valid complaint or not. What you've got through alternative dispute resolution services and what other services are available to you are, you've got mediation services. So mediation services might speak with both parties and try and find a conclusion that suits everybody. Through alternative dispute resolution services, you might find that they operate in a similar way to what a court might do. And you might well find that whoever adjudicates over the complaint, it could be legally binding if you accept it on the party of the repairer. So they should look at it within the confines of the law and the Consumer Rights Act. I said, and then the worst case scenario is if you end up in court. So hopefully I've covered as much as what I can do on the court side of it whilst not going too in depth of it. So that concludes the training for tonight. And then again, just open up to any questions you want. So at that point, I will stop recording.